from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to the second in our 8-week series entitled Know the Law. Our staff some time ago worked with me, and we decided it would be very helpful to you to talk about different aspects of the law, and particularly we're trying to have attorneys on our program that can discuss some suggestions and tips to you that could be helpful as from time to time you have certain questions that involve the law that would be very pertinent to your own personal lives. In the second week, we're going to discuss the law and landlord-tenant issues. For our good viewers in Oregon, Washington, Montana, and Canada, some of the issues that we discuss will be pertinent only to Idaho under the Idaho Code. However, we hope in this program and others that we're going to discuss a number of general suggestions that would be helpful no matter what state you live or even in Canada, because we're not going in those particular areas be specific to a particular state's code. So we'll do some of both in this series. I'm so pleased to welcome to the program two friends of mine who I've known a long time and who have practiced law in Idaho a long time and certainly know lots about this subject as well as many others. First of all, I welcome Linda Judd to the program. Ms. Judd has practiced law, as I said, in Idaho for a number of years, and in addition to her general practice, she has served on the judicial commissions and studies in Idaho and helped with a number of the codes over the years, and we've had her on the program before to deal with some of her legal work and scholar articles and so forth she's done. Linda, as it has been in the past, it's a pleasure to welcome you back to our program.
Thank you, Tony. It's a pleasure to be here.
Our second guest today is Norm Gissel, who is also an attorney in the state of Idaho, and he was on the program before on a number of subjects. In addition to his general practice of law, he has served on many boards and has also been very active in the field of civil rights with the Kootenai County Task Force on Human Relations. And like Ms. Judd, he is also very familiar with landlord-tenant issues and has had a lot of clients in this area. And again, Norm, it's a pleasure to have you on the program.
Thank you, Tony.
And as always, I'm pleased to have a panel to assist me in questioning our guests on this important issue. First of all, regular panelist Janelle Burke, who fortunately is an attorney for this subject, and she's also the law clerk to Idaho District Judge Gary Heyman. And next to her is Lloyd Marsh, who is a visiting panel member from time to time, is on the faculty at North Idaho College, and we're very pleased to have Lloyd with us. And I shall at this time ask Janelle to commence the questioning.
Linda, I know there are going to be a great number of our viewers out there who are involved in renting or as either a landlord or a tenant. How is this relationship formed, a legal relationship to which people have responsibilities? How is that formed?
Can be formed very casually, simply by an oral communication of an individual with an owner of property, and the individual asking if the property's for rent and indicating that this individual would like to rent the property for a specified period of time, or maybe just rent the property now with the idea that it's a tenancy at will that it kind of travels over time as a month-to-month tenancy in effect. So it's very casual, or it can be in writing. There can be a written agreement that's more formalized.
So it can be a very detailed kind of thing, or it can be quite casual.
That's true.
And as long as there is a meeting of the minds, would you say it's a contract?
Yes, it is a contract.
And would you say there's a difference between a lease as opposed to a month-to-month tenancy, a rent kind of agreement?
I think generally that the concept of a lease raises to mind a written agreement over a specific period of time, such as 1 year. And a rental agreement kind of brings to mind the idea of an oral communication, or can be in writing, but a communication between an owner of land or an owner of property and an individual who wishes to rent that property for a period of time, maybe an unspecified period of time.
And now, Norm, let's turn to you and just follow this relationship on through here a little further. Suppose that as we go along, the person has they have a pretty definite commitment as to what constitutes the landlord-tenant relationship, at least at the beginning. But now, suppose the year has passed. It was a tenancy for a year, and it's passed. What happens next?
What happens next is that the two parties, the landlord and the tenant, either decide to re-agree for another extended period of time, say for a second year, or it automatically will fall into a month-to-month tenancy agreement. And so long as the tenant offers an appropriate amount of money and the landlord accepts that, then that tenancy agreement that was for a year now becomes one for month to month to month until for some reason it does end.
Suppose that during this period of time there's a disagreement, or the parties wish to make a new agreement. And let's deal first with the second aspect of that question. Suppose the parties decide that they want to change the agreement. What happens? Can they do that during that period of time?
Yes, of course. Both parties can change that agreement with the consent and agreement of the other party. Frequently, however, in those types of situations, one party wants to change and the other party does not. And then the legal friction starts at that juncture.
And what is a possible solution to that? Is there a possible solution by redrafting, for example, if you have a written agreement, or by reaching a new meeting of the minds with respect to what constitutes the landlord-tenant relationship?
There are often negotiations between a landlord and tenant. The landlord might need some more money because his taxes rose, but if it's a residential lease, the tenant may have had a misfortune in his job and not be as fully employed as he once was. And so there's a competition between the landlord needing more money and, say, the renter needing to pay less money. And they'll have discussions over a period of time about how to resolve that.
Now, superimposed, Linda, upon this contractual agreement that the landlord and the tenant have are also some requirements, general requirements, that the government has placed upon landlord-tenant relationships. And can you indicate sort of how that works, that we look to the code then for additional terms, if you will, that the landlord and tenant must conform to?
Yes, I think most states, certainly Idaho, has code provisions that regulate this relationship between the tenant and the landlord. Some of those code provisions relate to sanitation and safety, health concerns for the tenant, and sets up a method or a mechanism by which the tenant can redress some problem areas that have to do with health or safety or sanitation of some type. For example, another area in which the code often applies is in the mobile home park tenant relationship, because that's a special factual relationship that requires certain protections. And a third area is a protection for the landlord, where there has not been a payment of rental at the time and in the amount that was specified by the original understanding or written agreement.
And I might add just along that line too that there are sometimes special condominium rules that have sort of a crossover between the landlord-tenant and strict property ownership, at least in my mind, that there are some aspects, but that people might want to go to the code if they were condominium owners to look for what the code provisions would provide.
That's correct.
Norm, along the same lines, when you have someone who stays beyond the period of time, our law provides for peaceful resolution of some of those issues. And can you tell our viewers what is the name for a person who holds over and they wish to get that person removed? I'm thinking along the line of unlawful detainer. Yeah. Our viewing audience may not recognize some of those terms of art.
A tenant who is there without a contract is a tenant at will, as Linda referred to. And that is the most tenuous relationship that you can have to a piece of property and still have a certain element of right to the property. And then there's people who hold after, say, a court has told them to get off, and they're still there. Those people are, I think they're referred to as tenants at sufferance. They're people that are just almost like trespassers. They have no rights to the property. Once a court has said you have to get off the property for the following reasons, and then list those reasons, those people then become mere trespassers.
Lloyd Marsh.
Well, my question relates to the rights of landlords and tenants in the fields of discrimination. I mean, what rights do landlords have and what rights do tenants have to rent? In other words, if I don't want to rent to you, what are my rights to say, I don't like the way you comb your hair? Can I deny you a rental if I've advertised it as rental?
Well, if you discriminate against me because of my race or my color or my condition of previous servitude, and I think now with the civil rights laws because of my sex, I think that I can cause you a good deal of problems, particularly if you are a large landlord, or if, for example, if you are a motel owner. Certainly, you're then in interstate commerce, and the federal rules apply, and you cannot discriminate in those areas, particularly if you're a large landowner.
Well, what if I would address this to Linda? If here I am in Coeur d'Alene and I have 3 houses and I would like to rent them, but I don't want to rent them to students because they're destructive or they cause problems. Can I deny them if they come and ask to rent the house? Can I deny them?
A specific answer to your question would require more specific facts, but generally speaking, that would not be a basis to deny the rental. Now, if you had a specific situation and you knew something about the background of a particular individual that was coming to you asking to rent the property, and you had then this factual background, this basis to make a decision, that would be different. But just to categorically assume all students are going to be bad renters, you're asking for some problems from some of the federal regulations and statutes. We're going beyond maybe just the state code provisions. But
so if I denied that student the opportunity to rent this house, then that student could take me to court and possibly and force me to rent, or at least provide some remuneration for denying them the rental property. That could happen.
Certainly, a student can take a landlord to court for almost any claimed mistreatment or breach. But it would depend on the specific facts whether or not this student would recover any remuneration, as you indicate. But yes, there is a potential for some litigation there.
Can we just add one thing in here, and then I want to move into another area? We're dealing with 2 things here, and that's why an attorney can never give exact information without knowing all the facts of the case. One is that in the United States, there's the civil rights legislation that covers housing, but then each state has the option to have additional laws, and so some states are more specific than others about discrimination that even goes beyond the federal legislation. But am I not correct that there are some circumstances, if you're not in the real estate business and you're not renting a large apartment complex, maybe you just have one house that you're renting, at the federal level there's some exemption if you're not in what we call, I guess, major business of renting, that they are like, they have the Miss Murphy, they called it exemption in the 64 Civil Rights Act, that if you have, it's my understanding, if you have a home, say a widow, and you were renting only one room in your house, you're not covered by that federal legislation. Is that correct?
Yes.
That's correct.
That's correct.
So we need to make the distinction between, on Lloyd's question, I think, about how much are you in the business.
That was the distinction that I was trying to make,
Right.
that you have to have some impact on interstate commerce before the federal regulations can impact your business.
I'd like to move into an area that just, I always think of our viewers of getting as much help as they can from our program. That's our purpose for being, and to be educational, informative. We have some viewers that are watching that are landlords, I'm sure. We have other viewers that are watching who are tenants. as you're preparing to, or preparing to get into this business, if you aren't already, I would like to ask Linda first and then Norm, what are some suggestions as we go through? I know more and more landlords have written leases, and sometimes they're 2 or 3 pages long that they ask the tenant to sign. And the tenant is also concerned about committing themselves for a period of time, particularly if they're in an economic situation where they may not be able to stay for very long, or they may have to move to another state for a job. Could you kind of take us through some points that both sides should watch? We've been brief on that so far about, obviously you're going to rent the apartment or the home for a certain amount per month, but what else are the factors that both sides should look for before making that final agreement, particularly if it's going to be a lease for 1, 2, or 3 years?
Well, it depends somewhat on the actual facts again, whether we're talking about a family or are we talking about just an individual renting a small apartment or a home for the family. But as a general consideration, I think both the landlord and the tenant need to analyze the insurance requirements that each are likely to have with respect to this living arrangement, this residency. Certainly, the landlord wants to protect the asset, the home, from fire and hazard of various type.
So, Linda, we're saying that the landlord will probably have insurance on the building itself if it burned, but the landlord may not have any insurance for the personal property that the tenant will have when they come in.
That's correct. And very often this should be clarified in the written agreement so the tenant understands that if there should be a fire, that the tenant's personal property may not be covered by the landlord's insurance and that the tenant would want to purchase his own insurance. And if that isn't to be the case, then it should be clearly indicated in the written agreement where the liability or where the risk will fall in the event that there isn't insurance for the tenant's property.
What else should they look for other than, and let me be arbitrary and say that, or an example, say, let's suppose the rent is $600 a month for a home. And then the second point you made is the insurance. Also, should they be very careful about, in addition, are there any other financial obligations other than $600 a month? Maybe there's a deposit for damage, or how about the utilities?
Yes, generally speaking, I think it's very normal for landlords to require a deposit, and the deposit very often is equal to a couple of months' rental, and that's basically to cover such things as the perhaps cleanup of the apartment or the house at the termination of the lease arrangement, to cover any damage that might occur to the building that's beyond the normal, reasonable wear and tear of the building, because the tenant isn't responsible for the reasonable wear and tear during the tenancy, but the tenant is responsible for extraordinary kinds of damage. And so the security deposit is a very important item to cover in the lease agreement, and utilities are another item that you mentioned. There's often an issue between the landlord and the tenant as to whether the utilities should be in the name of the tenant or should the utilities be in the name of the landlord, and then who has the responsibility, the landlord or the tenant, for any outstanding utility bills at the end of the lease agreement. So those things should be specified and clearly written before.
I think I hear you saying that whosever name it is in would be responsible for paying the utilities.
Well, that is often the understanding. It isn't always the legal result. There have been some case decisions in this area, and it depends somewhat on the municipality, for example, how the municipality looks at this utility contract, if you will, between the user and the provider of the utility service. But I think NAMPA was involved in a lawsuit a few years ago in which the city of Nampa viewed the utility arrangement as one affecting the real property, regardless of whose name the utility bill was in. And the court looked at that and said, no, that is a personal arrangement. A tenant coming into the property, even though there's an outstanding utility bill from the prior tenant's usage, can obtain water or electricity, whatever the city is providing, in his own name, and he isn't barred from getting that service if he has not paid the preceding tenant's bill. So there's been some litigation in this area. And
in other words, that's a good question to ask, too, to
Yes.
find out if everything is clear. Norma, can we have you to proceed a little bit further on some other requirements? I know one thing is that there's always issues about animals or those kind of things.
The landlord has a right. I'm thinking of my own experience. I am a landlord. We had no pets in this house, and that was understood by my tenant to have 2 litters of cats in the house. So there's quite a difference between my understanding of those limitations and her own. But that's a big thing, particularly after they've left. I mean, it takes lots and lots of money and time to deodorize a house. Well, for 2 litters of cats, for example.
Are those grounds for, if it's part of the agreement and they violate that agreement, that would be grounds for asking them to move prior to the end of the lease?
Absolutely, it's grounds for eviction.
Okay.
Yeah.
There's a question there, too, is that if there is this conflict and a lease has been violated, and say it's the middle of the winter, and here in the north where it's very cold, even though they may have violated the lease, do they have a certain amount of time to find another place?
No. That's one of the great myths of landlord-tenant law.
In Idaho.
In Idaho. And I think most everywhere. I've had people tell me you can't evict somebody when there's snow on the ground. You can't evict a pregnant woman. You can't evict people with children generally, or while children are in school. All of those are legal myths, and they have no basis, at least in Idaho law.
I have one other question, and I'll return to the panel. Also, if one had, say, several rentals, and one had a tenant who was quite ambitious, and what if they went out and on their own without permission, made some changes in the building or did some construction without your permission, or even left a bill? What, under Idaho code, what is the issue there? How do you resolve that?
Go ahead, Linda.
It can depend upon whether the construction or the addition to the building was a benefit to the property or was in fact a detriment to the property. So it can be a case of maybe the landlord becoming unjustly enriched by the tenant's work on the building, or on the other hand, it could be a case where there's been waste to the property by the tenant's actions. So in either event, there is cause for litigation to recover damages from the party that feels that there's been a damage, and if he can prove the facts that are required to show that he has a cause of action and actual damages did occur, then that damaged party should be able to recover.
Is it wise to put in a lease? Sounds like there's a need for a written agreement with all the possibilities that can happen. Is it wise for a landlord to put in the agreement that there would be no changes without the landlord's permission?
It is really a wise thing to do.
And then it's more binding than whatever happens.
Yes, the intent of the parties is then expressed in the agreement.
It's more clear to prove to the court.
And that's right. The proof element is very different.
Janelle Burt.
Well, it's not always possible to put everything in that written agreement, and so there's always going to be some room for interpretation in a lot of areas, oftentimes. But it does seem to point out that it's very important to have understandings between the parties as to what is going to be the case with regard to renting. If you have damages, there is such a thing, Norm, as I understand it, as ordinary wear and tear. Were your 2 litters of cats ordinary wear and tear?
No, I didn't think they were at all, and what they did to my house is really beyond description. But no, the ordinary wear and tear is just the
that we're talking about. What
yeah.
what are we talking about when we have in this lease agreement or in this rental agreement ordinary wear and tear?
Well, if you have a rug in the house and you rent to somebody for 5 years, you're going to have a 5-year-old rug on your hands, and you're not going to have a 20-year-old rug on your hands. You're going to have a 5-year-old refrigerator and a 5-year-old stove. You can't have a stove that ceased to operate because of a tenant's of handling of that refrigerator, and you're not going to have a stove that has the hinges ripped out of the oven. You know, this points out the basic problem of for the landlord, the most important moment in that whole landlord-tenant relationship is the moment that they've decided whether or not to rent to the tenant. Every landlord looks for somebody with the instincts of Mother Teresa and the earning capacity of Donald Trump. And conversely, that's what the tenant is looking for, is someone that's very nice, doesn't need to make a whole lot of money on the property.
So the landlord has certain things that they're trying to do, and they're trying to make sure that their property is protected. At the same time, if there is a breach, that's what we would call that time when one of the covenants of the lease, one of the agreements is broken. Is that what you would say, Linda, that you have then a breach of this agreement? And at that point, the person should probably refer to their contract, if they have one, to see if they're a landlord, what are they going to do? If they're a tenant, what are their rights? So can you expand on that a little bit?
If there has been a breach, in the opinion of the landlord or the tenant, hopefully there is an opportunity to talk about that with the breaching party, discuss it, and reconcile the differences. If they cannot reconcile the differences between the two of them, then perhaps litigation becomes involved and a complaint is filed with the court.
And Norm, in some cases, your contract will actually spell out what you have to do. Is that correct?
Yes, I mean, as far as
as a breach, when a breach occurs, what are the remedies? What are the possibilities?
Occasionally they do. The ones that I draft don't normally have that because the Idaho law is so specific in that area, and it's the Idaho law is very advantageous to both sides, and it's condensed, very fast litigation. So you can't. It's hard to improve on the Idaho law for a landlord or a tenant.
It might be eviction, but on the other hand, it might also be just say that the tenant is not happy with the repair that to the damages, or repair to the leasehold. Suppose that the leasehold
We're just about out of time.
is not very good. Then the tenant might want to give notice. Is that correct?
Right. They have notice requirements that demand very fast and prompt action by the landlord.
On that note, we have to bring our program to conclusion. On behalf of the panel and the staff, we want to thank Linda Judd and Norm Gissel for participating in this series, Know the Law, and you certainly have been most informative, and I know you've helped landlord and tenant personnel with this important question. Ladies and gentlemen, I would invite you to be with us again next week on program number 3, when we will deal with the issue of bankruptcy. We believe that program, too, will be most informative and helpful to you. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.